this hearing in this meeting. It's hearing number 3. And the purpose of this is to assess information on the situation of due process in Trinidad and Tobago, and I'm very grateful for our very dear Rosemary for being here today. Former president of this commission, I thank you for being here today. And I wish to point out that we are very much regret the fact that the state is not here today, because this mechanism of holding hearings affords the Commission an opportunity to also hear the position of the state, to hear the state's arguments, and if the state is not present, we cannot do that. We additionally wish to thank people who are here in the audience to listen to this hearing. So we will immediately begin this hearing with the ringing of the bell. And I also thank my other colleagues who are here at this table. We have Commission Member Antonio Urrejola, who's the second Vice Chair of the Commission and the Rapporteur for Trinidad and Tobago. We also have Commissioner Margaret May Macaulay, as well as Commissioner Francisco Eguiguren. We don't have any of the special rapporteurs here right now, but we will immediately get started. And once again, please forgive me, I can't speak in English because my English is really bad, but I will hear you through the interpretation. You have the floor. You may start.
President, Commissioners, the Human Rights Clinic, Faculty of Law, University of the West Indies, St. Augustine, thanks you for this important hearing. I am Rosemary Bell Antoine, and with me are Janelle Crosby and Shira Watley. I acknowledge also the work of Aliyah Espinoza Lewis and the entire clinic. There is no greater freedom than freedom itself, and where the state is entrusted with managing the criminal justice system, detaining persons and depriving them of their liberty purely to secure their attendance at trial for offenses for which they have been accused but still innocent of, it must do so with every safeguard of this foundational freedom, protected in every known human right instrument and a core tenet of the rule of law. Such remand detention must be kept to the minimum necessary to safeguard the public's interest. And we know that the Commission has done very important work on this and offered guidance in its press releases and reports and so on. Both the Commission and Court have pointed out that pre-trial detention is limited by the principles of, quote, legality, presumption of innocence, necessity, and proportionality. It is precautionary and not a punitive measure, and should only be imposed in exceptional cases. Yet, in Trinidad and Tobago, these internationally accepted norms are typically ignored in the remand system, despite the fact that they are also entrenched in the Constitution. Moreover, these violations have not been addressed or addressed adequately by the courts to date. In fact, there is a long-standing and pervasive problem whereby large numbers of persons arrested for criminal offenses are forced to endure excessive, unjustifiable periods of incarceration and remand while they await trial, often in excess of 10 years and more. Given that such persons have not been proven guilty and remain innocent in the eyes of the law, such incarceration, often in documented inhumane conditions identical to convicted prisoners, constitutes core human rights violations. including due process, the right to a fair trial, liberty and dignity, as well as concerns about inhumane punishment enshrined in the American Declaration on Human Rights. It also jeopardizes the safety of prison officers. The problem of excessive detention and remand has assumed exorbitant proportions. In some cases, the period of remand reaches the length of the longest sentence that could be imposed for the crimes charged, or even exceeds it if found guilty. Alarmingly, Trinidad and Tobago has the second highest remand population in the region, second only to Haiti, with some 60% of prisoners on remand, so that the majority of persons suffering in our jails have not even been found guilty of any crime. Of the more than 2,271 prisoners on remand, 34%, or 1/3, have been incarcerated for more than 5 years, while 12.5% have been on remand awaiting trial for more than 10 years, even incredibly 21 years. In June 2019, we saw the latest example of such travesties when 3 men who had been on remand for 10 years were found innocent and acquitted of murder. When our clinic visited the prison remand population to further interrogate this issue, we observed a distinct and disturbing pattern. This is a link between female remandees incarcerated for murder and gender-based violence, revealing a sub-layer to the already urgent general remand problem. Such women had been victims of domestic violence and were now accused of killing their partners. We therefore contend that within the remand travesty, there are also serious infringements of the right to equal treatment in terms of its gender dimensions. It is one, like so many other gender issues, that has been invisibilized. Statistics reveal an alarming 58.5%. Nearly 2/3 of women remandees on charges of murder are victims of domestic violence, at least those we know of. Some of these women have been on remand for over 12 years awaiting trial. Such phenomena are only now receiving worldwide attention. A 2018 Cornell study reveals gender biases in the criminal justice system and illustrates that, quote, most women have been sentenced to death for murder, often in relation to the killing of family members in the context of gender-based violence, unquote. It links this to systemic discrimination against women in society. The current paradigm exposes significant gender dimensions, accentuating the vulnerabilities of women on remand in Trinidad and Tobago, underscoring structural patterns of gender discrimination. This is in the context of the well-documented high prevalence of gender violence. Domestic violence is a long-standing and serious issue in Trinidad and Tobago, which, despite interventions, still occurs at an alarming frequency. Indeed, statistics show that in 2018 there were 1,244 reports of domestic violence and several deaths. This scenario exacerbates their already vulnerable situations as victims of gender violence, placed further at risk by a system that has failed to proactively address their situation. Inevitably, too, gender variables intersect with socioeconomic vulnerabilities, accentuating the problem. The National Women's Health Survey noted the, quote, major stumbling blocks for survivors of gender-based violence as the inefficacy of law enforcement, a judicial system plagued with inordinate delays, the high costs associated with attorney fees, and inconsistent bail matters. Similarly, we highlight the significant underlying socioeconomic dimensions of remand injustice in Trinidad and Tobago, another element to the question of equality and equal treatment before the law. These rights infringements continue despite long-standing complaints about the system and even formal investigations by state-appointed committees including a joint select parliamentary committee focusing mainly on remand conditions, which confirmed the need for reform. Recommendations of these committees and other stakeholders have not been implemented, and the situation has worsened. We accept that the reasons for these long periods of remand are multifaceted, multi-sectoral, and complex, involving the police investigation system, the judiciary, prosecutors, private attorneys, bail and legal aid systems, and more. While some of these actors are not directly controlled by the state, we contend that the accountability for appropriate legislative and administrative reform resides in the state. Further, international obligations are either not understood or ignored, resulting in harsh and inhumane justice systems. There is little acknowledgement or awareness by the several stakeholders that prison and remand systems must be enveloped within a human rights framework, as must the entire administration of justice, which has the ability to deprive persons of their fundamental rights to liberty. The public, like the state, are largely apathetic, given the assumptions made that anyone on remand must be a criminal, and the fear and draconian impulses invoked because of the current high levels of crime and citizen insecurity. This impulse to stereotype and warehouse large numbers of persons, typically fitting a particular socioeconomic profile to attempt to curtail crime, as illustrated in the now discredited war on drugs, is also a pattern in the region, which, as the Commission has documented, results in ineffective solutions to solve crime. Consequently, there is a wall of silence and lack of real attention paid to this dire situation. These are forgotten and invisible people. Yet, the processes promulgating remand injustice are those which the state has the ability to regulate and influence to avoid these current human rights abuses. The remand travesty is a collective and institutional failure which offends the basic norms of the justice system and will require a piercing commitment from many stakeholders to resolve. We therefore wish to build awareness of the serious infringements of human rights at stake and advocate for urgent reform to law and policy.
In Trinidad and Tobago, excessive pretrial detentions are not, as required in international human rights law, necessary or proportionate in order to secure the appearance of the person at proceedings or to facilitate the shortest time possible. This thus offends a framing principle of all international instruments on human rights, as embodied, for example, in Article 1 of the American Declaration that every human being has the right to life and liberty. The excesses of the remand system also violate the right to a fair trial with a brief procedure as enshrined under Article 18. The Inter-American system has been clear that fundamental rights are violated when undue delay in bringing cases to trial occurs, particularly in situations when accused are in pre-detention. These rights are designed to avoid keeping people too long in a state of uncertainty about their fate, and if held in detention during the period of the trial, to ensure that such deprivation of liberty does not last longer than necessary in the circumstances of the specific case. Thus, it has been consistently held that persons are not released pending trial must be tried as expeditiously as possible. In the Trinidad and Tobago case of Hilaire Constantine, Benjamin and others, the Inter-American Court pronounced on these issues with regard to a murder accused who alleged due process violations arising from alleged delays, deficiencies in their treatment and condition of detention, and denial of access to legal aid. The court found violations of the right to be promptly brought before a judge, a trial within a reasonable time, and a fair trial. Municipal courts have tended to accept without question the state's defenses of scarce financial resources in these challenges. For example, In Sukamani and the DPP, the High Court said, the problem of institutional delays is a complex one to which there may be no simple ready-made solution, and the scarcity of financial resources is clearly a factor to be taken into account. The court is entitled to take into account the prevailing system of legal administration and the prevailing economic, social, and cultural conditions that are found in that particular country. Yet, the international human rights law today imposes stricter standards. While we accept that scarcity in resources is a legitimate factor, it is neither the only reason for delay nor is it insurmountable. Just as important are the structural deficiencies and attitudes in the system which mitigate against better justice. Due process of law as protected under Article 26 is viewed as an umbrella right, even in our courts. It safeguards other fundamental rights and freedoms, and its assertion that every accused person is presumed to be innocent until proved guilty is key to the securing of a fair trial and the protection of liberty. International law has required that deprivation of liberty must be an exceptional measure supporting the presumption of innocence principle which governs the judicial process and is a right owed to anyone charged with a crime. Where the accused is detained during the pre-trial process and the case takes extremely long to go to trial, the presumption of innocence is jeopardized. Indeed, excessive periods of pre-trial detention assumes instead that accused persons are guilty, not innocent, and thereby contravenes international standards. As the Inter-American Court stated in Ricardo Canis and Paraguay, the right to the presumption of innocence is essential to the effective realization of the right to a defense and accompanies the accused throughout the trial proceedings until a judgment determining his guilt is secured. 13 years remand has been sufficient to find human rights violations of Articles 7 and 8 of the Convention. The infringement against the presumption of innocence is exacerbated for women remandees linked to domestic violence, since until the matter reaches trial, they are unable to raise lesser charges to which they may be entitled, such as self-defense against abusive partners, slow burn provocation, cumulative provocation, diminished manslaughter, or temporary insanity due to the well-documented impacts of long-term abuse. All are charged and remanded simply for murder. Despite these potential defenses, these women find themselves deprived of their liberty for extensive periods due to the slow pace of justice. Thus, in the structural paradigm of vulnerability that confronts women, women are doubly disadvantaged. First, the state fails to adequately protect abused women, and subsequently, the criminal law and judicial system further prejudices women who kill their abusive partners, treating them like cold-hearted murderers. The delays in gathering evidence is one factor in the problem. However, international law has consistently noted that delay due to evidence gathering is not enough to justify the lengthy passage of time between arrest and trial, as the Human Rights Committee noted. It emphasized that a lack of adequate budgetary appropriateness for the administration of criminal justice does not justify unreasonable delays. Institutional delays such as those caused by lack of resources are also inadequate in justifying lengthy pretrial periods. Several other factors cause excessive pretrial detention. Some are structural, institutional, or evidential in nature. Attorneys themselves blame the slow pace of producing evidence for preliminary inquiries and preparation of trial, particularly with the small pool of criminal defense attorneys who, it is claimed, tend to put off all other competing matters when on a trial, requesting a series of adjournments by court, which are usually granted and effectively stall other criminal cases under their management. The limited number of courts are also blamed. Further, the DPP has complained that his office lacks financial autonomy, which leads to severe staff shortages and even basic office supplies and facilities needed for expeditiously dealing with cases. Under the broad rubrics of due process and the right to a fair trial, the right to bail is also prescribed. When examined with the parameters of remand, further injustices are apparent. Bail is typically not available for murder charges. Where bail is available, it may not be affordable. Bail issues are a constant complaint among remandees. Problems are more than the cost. For example, prisoners at Golden Grove said that they were brought before the court infrequently for bail hearings. Prison officers admitted that there was a period of 3 months where transport vehicles were unavailable. Consequently, no remandee was able to attend bail hearings. If remandees cannot access bail, they cannot pay bail. We believe that the bail system should be reassessed and reformed as an alternative to remand in Trinidad and Tobago. These deficiencies also make alternatives to pre-trial detention, including electronic monitoring permitted under law but not implemented, even more important.
The issue of access to justice is a major component of due process.
El tema del acceso al debido juicio, el contexto de privación de libertad, resulta ser una herramienta fundamental para el
Go ahead. In the remand context, free legal aid is a vital tool to fulfilling the requirements of legal representation, given the typical socio-economic constraints of the remand population. Legal aid is an essential element of a fair, humane, and efficient criminal justice system that is based on the rule of law, a precondition to exercising rights to a fair trial, and an important safeguard that ensures fundamental fairness and public trust in the criminal justice process. The UN Principles and Guidelines on Access to Legal Aid in Criminal Justice Systems also acknowledge that certain groups are more vulnerable when involved with the criminal justice system and deserving of additional protection. It provides specific provisions for women, children, and groups with special needs. It also encompasses the right to effective legal aid as contemplated under Mandela Rule 61.3. In our interview sample, a high percentage of remandees utilize legal aid service. Of that percentage, 95% of the women were charged with capital offenses related to domestic violence, illustrating the financial vulnerability of such women. At present, there are no specific provisions granting special protective treatment for these vulnerable women. The situation is compounded since 95% of the female remandees expressed dissatisfaction with the quality of the legal aid representation that they received. One remandee in particular indicated that she had only seen her legal aid attorney once in the 11 years she has been on remand. Poor legal representation is an important factor in prolonged delay in court trials. There is consensus that cases are prejudiced by the excessive and undue delay. Prisoners complain that for those on murder and rape charges, their cases are compromised due to the heavy reliance on witness statements, which depend on witness memory and in turn adversely affect evidence and trial testimony. Further, there is a culture of adjournments which not only frustrate witnesses but deters them from cooperating because of possible job loss and loss of financial earnings. Because most cases usually take over 5 years to go to trial, these factors gravely affect the strength of the defense and undermine the fairness of a trial, especially when the delay is unjustified and not attributed to the actions of the defense. Very recent initiatives by the judiciary to access a backlog of criminal cases in the criminal courts involving expedited trials or pleas, status hearings, maximum sentence indications, and case management directions are laudable. However, these measures are symptomatic rather than preventative, focusing on ameliorating the delay after it has already been arisen and after the accused's rights have possibly already been infringed. It does not treat with the multi-sectoral aspect of the problem, which only the state can impact in a proactive way. To illustrate, some persons in the system who wanted to plead guilty but were never indicted ended up spending more years on remand than their sentence, such as Bido Valen, who spent 6 years on remand, pleaded guilty and received 4 years for a drug offense. One NGO also cautioned that some prisoners are pleading guilty under the program because of their desperation to escape the state of uncertainty they have been residing in for years, so they are willing to surrender their opportunity to prove their innocence. Remandees, although still innocent in the eyes of the law, are treated in identical fashion to convicted prisoners in harsh prison conditions. For example, remandees are not allowed to be outside of their prison cells for more than just 1 hour per day. 1 to 8 remandees share a cell which made to accommodate only 2 prisoners and all of the remandees. Thank you.
Gracias y disculpa.
Thank you, and my apologies for the interruption. Let me recognize Gerald Wilson, Commissioner for Prisoners in Trinidad and Tobago, who is visiting with us via the internet.
What is happening now, and we are seeing persons on remand for some average of 8, 10, 14 years. It doesn't give the inmate himself or herself any hope and frustrates them, which also brings a burden on the prisons officer as we look at it. So that we have to look at the judicial process, we have to speed up matters so that persons will not spend that length of time in prison. Sometimes these inmates may wake up and tell you, today did you invite me? Because it means that they are overwhelmed by the situation at times. And you as the officer have to be sympathetic and show a lot of empathy. And that particular morning, the officer himself or herself will not be in such a good mood, so that it creates, this time bomb. And that is why, if you notice, the remand is always the volatile place. We take them out for 1 hour and put them back. So 23 hours you're locked in. And then you just come out to eat in the morning for lunch and the evening. But you don't come out yourself. I've been extremely concerned about the fact that when persons are incarcerated for that length of time, families are affected. Because sometimes you just look at the person who is convicted or is charged, but you don't ever look at what happens in families. So that when a person remains in the remand for that period of time, it affects them psychologically, sometimes physically, and you see deterioration in them quite quickly based on the length of time that they're here. We have a unique situation in Trinidad where a remanded inmate could spend up to 14, 15 years. If that is the case, then I think it's important that we have programs for them too. Because you have someone and you are saying that, okay, this person is remanded, so you don't expose them to programs. But after 14 years, what happens? They don't have a skill, we didn't deal with their anger management, we didn't do anything about them, so they return to society the same way, or probably worse than. If we look at what is happening now, and we are seeing persons on remand for some average of 8, 10, 14 years, it doesn't give the inmate himself or herself any hope and frustrates them, which also brings a burden on the prisons officer.
Muchas gracias.
Thank you very much. It is at least hopeful to hear the position of this gentleman who is acknowledging that there is a situation that requires a response and a reform. let me give the floor to Antonia Urejola as a special rapporteur for the country.
President, thank you very much for all the information you have given us, and I'm happy that at least we had a video from the representatives of the state. It's a pity that nobody was here, because actually he's recognizing what you have said, and it would have been an opportunity to discuss with the state maybe a plan of action, because he's not only recognizing, but he put a point that you didn't even talk about, is rehabilitation. How do you say? Yeah, rehabilitation. I didn't even think about that. I was all the time you were talking about, you know, the pre-detention time, 14 years, 10 years, and he said they don't even have a program because they haven't been sentenced. So I mean, it's even worse than, you know, than the people that have been sentenced. And he's saying, you know, they're 14 years there, nobody's attending them, so, you know, they go out even worse with no programs, nothing. So he's even recognizing something that you didn't even talk about, and it's a pity we don't have them here, because maybe, you know, it was an opportunity to talk with the state and see if we could have like a plan of action with the help of the Commission to see how we as a Commission and you as civil society with the state work on a huge problem. And I know it's not easy, but actually, I mean, I think this is an enormous human rights situation that has to be addressed, and he has recognized it. Unfortunately, the state is not physically here, but maybe we could even, I'm just thinking out loud, send a letter to the state. First, send a letter to the state, yes, and to have a meeting, and maybe we could do a working meeting on our next session in Ecuador, and inviting them to see how we can address this problem together. It's an idea, I'm just, you know, speaking out loud, because I think you have addressed two issues that are related, but two important issues. One is the pre-trial detention and the abuse of it, which is, I mean, he talked about 14 years, you talked about 10, 12, more than 10, which is, it's a problem in the whole continent, but really, I mean, it's, I don't know how to, you know, what adjective to use, but it's something that you can't believe. I mean, how can somebody be in pre-detention all that kind of years without being sentenced, or finally not, you know, not even guilty? That's one issue. And then you addressed, you know, domestic violence, and you talked about, I think you talked about 2/3 of women that have been accused of murder are victims of domestic violence. Even though the issues are related, I mean, there are two enormous big issues that I think two different issues that are related, but two different issues, which is discrimination against women and domestic violence in Trinidad and Tobago, that I think Margaret will talk a lot about that too. So I think this has been a very important hearing for me as a rapporteur. I hate that word because I hate French. So, but first of all, thank you for the information. Really, I'm quite impacted with all the information you have given us. It's difficult to believe all the numbers you have given us. I mean, you talked about, you know, that the state sometimes has problems with attorneys, and there's not enough money to have attorneys, etc., etc. And you can understand that to a point. But when you talk about 2/3 of the women accused of murder are victims of domestic violence and have been 10 years in pre-trial detention, and I suppose that it's you know, how do you say when it's a secret that everybody knows? I mean, everybody must know that these women are there because they had to defend themselves. Everybody knows what the issue is, and they're still there for more than 10 years. I mean, something has to be done, and what what I want to say is that let's see how, I think the only idea I have at the point is maybe see if in Ecuador we could see if the state is willing to do a working meeting to see how we can address this together, and see how we can start working on an issue which I know is a huge problem, but step by step. So thank you very much. And I just want to ask one question. What happens with these people once once they've been more than 10 years or more, and finally the sentence is that they are not guilty? Do they have any recourse? Yeah, afterwards.
Yes.
Afterwards, they will ask questions and then you can answer me, because after you've been 10 years, or maybe they're sentenced to 3 years and they've already been 10 years.
Okay, gracias, Commissioner Louis.
Thank you, Commissioner. Let me give the floor to Francisco, Commissioner, so that he can ask his question. Thank you very much, Madam Chair. Thank you, Madam President. Thank you to the delegation for this very valuable information you've presented. I apologize, I have to leave early. I have another meeting to attend, but I do have a very quick question that I believe the Commission will be interested in having information on, and also because our special rapporteur for individuals who are remanded is not in the room, and they expect he would ask the following question. You've said that Trinidad and Tobago is in the situation of many countries across the continent where there is an abuse of remand, pretrial detention, and that is why the Commission issued a report on this topic some time ago. I wanted to ask you very specifically, knowing that pretrial detention should be an exception given the presumption of innocence, and that there should be procedural reasons for it that have to do with the behavior of the defendant, or that is a risk of flight, endangering the community, the specific actions, that is to say, not in the future, not past behavior. I wonder whether in Trinidad and Tobago, where there are any specific cases of crimes where necessarily pretrial detention is required, and if that is the case, does the judge have, in analyzing this specific case, the opportunity to not order such pretrial detention, or whether that is a prerequisite mandated by law in such cases? Thank you, Commissioner.
Thank you, Madam President. Yeah, this sounds very bad for the common law system. I must admit, I am a Caribbean person, a Caribbean lawyer, and Rosemary and I go back a very long way in women's rights and so on. I am shocked, absolutely shocked. And one of the reasons, as you know, in the common law system and the remand system, some people are remanded to a specific date to be brought back to court for the judge to check on the position of the case, and the judge to protect the constitutional rights of that person accused. And if the Crown, the prosecution, says they're not ready after a certain amount of time, and normally it is 2 sessions, the judge must release that person conditionally or unconditionally. So what are the judges doing? What are the judges doing? First of all, what are the even politicians doing, taking this sort of thing? Because the cost, the financial cost to the country by having so many people on remand is astronomical, which could be used by the DPP's office to enlarge his staff, and then you have more judges and more courts to move ahead very quickly in respect for these people's rights. What the heck is happening? Because And are the judges trained in human rights? Perhaps do you wish the commission to assist in this kind of training? Because clearly they need training. And lawyers, the Bar Association should be brought into the matter as well. If lawyers on legal aid only see their clients once in 11 years, that lawyer should have gone to court to apply for their client to be released, since the prosecution wasn't ready to proceed with prosecution. And you have the Caribbean Court of Justice right there on your doorstep. I am so stunned that I'm almost speechless about what is going on. And the fact that today in Trinidad, a woman who is a victim of domestic violence, who kills her perpetrator, cannot use that in defense, in her defense, cannot effectively use it. That's another training for the judges, no? So, as you know, you've been president of the commission, we do give technical assistance. I think Trinidad is in dire need of that. And the judiciary, the legal system, the Bar Association members, and more and more. The Commissioner of Prisons mentioned the fact this is a destruction of families. Families. If I am in jail for 11 years and I have my husband and so on, he's going to wait for 11 years and not go and get involved with so many other women and forget about me in jail. And then the children, young children who may be left behind without succor from their mothers who are violent, who were treated violently. Or a male who leaves his wife and children. This is terrible. I mean, I am stunned. I am stunned. Did you go to Trinidad and Tobago? Well, I wish we'd known this before, because then we could have put very hard questions to the government members that we spoke to. But I still think that we can, as the rapporteur for the country has said, Antonia, we can still send an Article 18 letter and ask some pretty strong questions. Could you give us copies of your presentations, because those figures in there will be vital for our use. I really am not going to ask any questions other than whether you want technical, you think you could use technical support from us. And do you have many cases of accused who are placed on remand during the governor's president's pleasure because of their mental state? And do they figure largely in that? Because the one case I know which was a big scandal in Jamaica was somebody who was forgotten, who had been detained during the Governor General's pleasure because of his mental state. And he fell through the cracks and was there for 21 years, and that was an enormous scandal. So, do you have that as well? And if so, could you figure them into the equation? Because if somebody is not mentally fit, they ought to be. And the question of women's lack of access to justice is apparent. And the others, all these people, the whole line of them, 60% of all prisoners, my God, their lack of access to justice is clear and apparent. So we have to do something serious. And thank you for bringing it to our attention. And we know that we will do what we can and be in contact.
Thank you, Margaret. The Deputy Secretary, Maria Claudia. Thank you, Madam President. At this time, since we have the interpreters, I will speak in Spanish. My question is more technical and has to do with the follow-up the commissioners have proposed. Is this possibility in Trinidad and Tobago of using alternatives to pretrial detention, particularly in the case of women, particularly given the differentiated impact of incarceration of women, particularly as the Commissioner has noted, the impact on children, on families, and I wonder whether that might be an option, alternatives to incarceration. And also the technical cooperation, whether that can be provided through the Executive Secretariat in the area of pretrial detention as a result of the report published on the excessive use of pretrial detention, and also the technical guidelines that are included there to help support civil society, both academia but also government employees. And lastly, ask whether you have looked at the possibility of using other protection mechanisms that the Inter-American Commission has, such as individual cases or precautionary measures, and I wonder whether you've presented specific information of cases of women who have been subjected to these conditions, or even men who have been in prison in pretrial detention for 10 or more years. Thank you, Maria Claudia. I would just like to make two comments that I think are important for the Commission, given the comments as well by the Commissioners and the Executive Secretariat, and that is practice of the judicial system. I wonder, is that the practice, or is it that the regulations permit this response by the court system? To talk about a transformation, talk about change, I believe it is particularly important to make that distinction. If it's a matter of practice, then we need to talk to the judges. As Commissioner Margaret has said, it's a question of training, of knowledge, of pretrial detention and the laws set forth in the country itself, whether they are being complied with or not. That's one thing. In addition to that, as Deputy Secretary has said, the Special Rapporteur for Incarcerated Individuals is preparing a report on women who are incarcerated. So any information that you may be able to provide to us on that specific topic will be extraordinarily valuable, because we are currently collecting information on the gender perspective of incarcerated individuals and seeing the impact of that on the life of the children and the impact on families. So it is very important to have that information available to us. Also, in response to the petition by the Deputy Secretary, it's important for us to have a set of specific cases. A list of cases of individuals who have been remanded, as you said, for protracted periods, as Rosemary has said, and particularly those who have been incarcerated for the full amount of time that would be the maximum penalty that they might suffer or more. me give you the floor to hear the responses to these queries.
Thank you, distinguished commissioners, for your comments, very helpful comments and questions. I'll do the one or two and then I'll pass it on to my colleagues. In particular, those to do with bail and how the law operates, and on the family, because one of my colleagues didn't get a chance to give you more information about the family, because we did expect a little more time because Steve wasn't here. So, but we do have more information. Just to say, on the point of technical assistance, we welcome that suggestion. I would say that, as you saw, we thought it was very important to bring the words of the Commissioner of Police himself, who's been working, although he's an arm of the state, also very much an advocate. And yes, all of these issues that he raised, he's certainly very interested in moving forward. So I think the judiciary, we did mention that there have been some recent initiatives, but we have said it's a multifaceted problem which requires all of the stakeholders, and we need the state to lead it. But we do think that there we have important, the aspects of the state, judiciary and so on, who can, I think, dialogue in a deeper way with the Commission, and we welcome that. The suggestion about other ways apart from letters, precaution measures, is certainly things that we will look into. Since our visit, women have in fact been talking to us over and over, those on remand, and it's certainly an important idea to move the agenda forward. Yes, we underscore again the structural gender discrimination that's taking place. There are one or two possibilities in the law, like electronic monitoring, that we might have mentioned, but has not been implemented. And also we did not get the opportunity to say to you that we have been observing what our neighboring countries have been doing. Jamaica was one that we pulled out as a good example after it had its own scare. You mentioned some of it, and so we are well aware of the recommendations and some of the things that they did in terms of time limits, as well as what the Commission in its reports and press releases have been advocating, and we do support those. So I think in terms of the technical assistance, we would certainly bring that forward. I'm now going to ask Janelle Crosby to talk about the bail issue, the family, and just to say, before I say that, we're not aware of any particular case in terms of mental illness, but we did make the point that women who have been constantly abused, there's all document about yes, temporary insanity and mental health issues, and in fact, my colleague may say a bit more about that too, as that continues in the remand, not surprisingly. So over to you.
So in Trinidad and Tobago, we have seen where there has been no change to the legislation. We still have no bail for murder, despite the different degrees. If it's self-defense, provocation, it's straight across the board, no bail for murder. However, which is very accurate. Jamaica, we have seen, has made a lot of strides in terms of the lengthy times remandees have stayed in prison, right? They have changed their legislation, and bail may be granted for murder by a registered magistrate or judge. So they have time limits placed on trials. Trinidad and Tobago does not have that. So we see a breakdown in the home between the parent, the child, and the mother, who now has to stay in remand to await her trial more than 10 years, sometimes 11 years plus. There's nobody there with the family, with the children, which essentially is a loss and a breakdown in family life, which are one of the key aspects. Even further, we see Dominica, Jamaica, St. Lucia, other Caribbean states making changes, yet Trinidad and Tobago still has not. Legislation needs to be changed. We need to have implementation of programs. Besides that, just programs and a future, something that we can bring the family and mothers can be there, even though they have to wait their trials to finish up. Last and finally, we see plans where people even stay longer waiting to get their sentences before the courts for trials, and sometimes they serve more than their sentence or the prescribed time for the crime. So in the case of Vido Valen, he actually served 6 years on remand before get into trial, and he was 4 years was his sentence time. So we see the disparity straight across the board. Thank you.
One thing. Antonio, Commissioner Antonio, and Second Vice President asked about how do you explain that sort of thing when somebody's been in remand for so many years and they tried and their sentence is passed, and if the sentence is, say, if they've been there for 12 years, the sentence is 12 years, the judge normally takes that period of 12 years into account and the man walks and goes home.
Yes, and that will happen as well. That kind of will happen. That kind of
yeah.
will happen in the courts. But as we were saying, very often you have already gone past, or in some cases at any rate. But that the judge can and will do that in Trinidad.
And is there a recourse in Trinidad? In Jamaica, if that happens, that man can sue.
We have not seen, our position is that there we really had no system of remedial measures, whether it is reintegration. It's just a forgotten issue, So we need to have structured programs in place for all of those things as well.
Yeah, muy bien.
Very well. Are we okay? I think this has been a very valuable opportunity to collect this information. As Margaret says, when you hear all of this, it makes you just say, how in the world can this happen? And the issue of responsibility that the state has for pretrial detention, which even exceeds the most severe punishment for the crime, is inconceivable. And if the person is acquitted, there must be some liability on the part of the state. So I believe that the proposal to offer technical cooperation is something that we can make an effort to coordinate by the Ecuador meeting if possible, and keep in touch with you regarding formulas we might begin to look into for some cooperation. Thank you very much, and that concludes this hearing.